So my name is Claudia Sternberg. I'm a Principal Research Fellow at the European Institute here at UCL, which sits in the law faculty but serves the whole university. And as a political scientist, I've just learned I'm not the only non-lawyer up here. We're here to discuss a recent judgment of the Court of Justice of the EU, Commission versus Malta, in which the court ruled that Malta's golden passport scheme or cash for citizenship scheme is illegal. The scheme allowed people who had given up to £750,000 to Malta, and at least in theory had spent 12 months in the country to gain citizenship. And this ruling and the court's reasoning has been attacked, both for overextending the scope of EU law or simply for being a political judgment, and for requiring an overly thick bond to exist between citizens and the state. But others have defended the court's approach precisely because of the importance that it places on such bonds. Our excellent panel tonight will discuss these issues, and I expect there to be quite a range of views on them. We'll start on the far end from my perspective, where we have Professor Dmitry Kochenov from the Central European University in Vienna, and then Sarah Ganti from the Université Catholique de Louvain and Yale Law School, and then our very own Oliver Gerstenberg here from the Faculty of Laws, followed by Lior Erez, who is also one of ours because he did his PhD down the road in the Political Science Department, or the School of Public Policy as it was then called. He's now at the University of Oxford, the Blavatnik School of Government, and en route to Sciences Po in Paris. And finally, Martin Samson, who's the director of the Migration Observatory at the University of Oxford. The plan is that everybody will speak for a few minutes before we open up to discussion. First, they get a chance to respond to each other, and then we open up for Q&A. Before I hand over to Dimitri, one important thing, a big thank you to our colleague Colm O'Kennedy, who has convened this beautiful panel, and without whom this event could not have happened, and also to Kat Balogun, who was just here, who's expertly looked after all the logistics, and also to our intern at the European Institute, Emmy in the back, for his work on all the comms. Thank you. Thank you for being here. And Dimitri, over to you.
Yeah, I will hijack this event where I'm extremely honored to be here, but I would like to speak not only about the judgment, but also about the book which the judgment has overruled, which is due to appear in 2 weeks. And I mean, the book is much better than the judgment, as will appear from this panel, I hope, because this is something that Madeleine and I concocted also with one colleague who is now in Leiden, but who started at Oxford, and we collected all the best thinkers delving into the nature of EU law on citizenship and trying to connect that to investment migration, including Joseph Weiler, including Ulis Rund de Rivera, the doyen of citizenship studies in the European Union, and plenty of others. So Hart has published the book, and then when the final proofs were corrected, and when we heard from the publisher that the book is going to the printers, the court drops this bomb on us, saying actually legal reasoning doesn't matter, and we don't care about what you all think and what the precedent suggests, because citizenship should not be commercializable, basically, and there are plenty of problems with that. So instead of just starting with those problems right away, I think we could look at the essential lines of evolution of EU citizenship law, or EU law as such, vis-a-vis the person, over the last, say, 20-25 years, to see where citizenship has been going and where it has started. So in the beginning, at least that's what attracted plenty of my colleagues and myself to the idea of European citizenship. What seemed like a really hopeful start is to have a citizenship which is protected from all which is immune to all the diseases of citizenship. So it's a citizenship that is not nationalist, a citizenship that is not hateful, a citizenship that is not that much exclusionary, and a citizenship that is based on the premise of the antipode of itself, non-discrimination on the basis of surprise, surprise, citizenship. So these are the main selling points of the internal market and of the European Union as a project 25 years ago. So then this project could be summarized referring to Gareth Davis's probably most quoted publication, where Professor Davis from Vrije Universiteit in Amsterdam tells us that the main constitutional tactic of the European Union is the humiliation of the member state. The member state tells you it's fundamental to speak Estonian, and the European Union then corrects, not quite. For an Indian, an occasional Indian who decided to settle in Estonia, this is fundamental. For a Romanian, not at all. And we will protect that Romanian. Then someone shouts, it's absolutely indispensable to establish permanent residence in our country in order to draw any pension, even in relation to the humiliation and destruction of your own people, like the case law from the Netherlands in relation to some Indonesians and colonial wars, who were Dutch citizens and chose to go to Spain and to live there on the Dutch pension. And the court corrects them, saying, no, actually, you're absolutely wrong. We protect these people precisely from this kind of claims. The European Union is precisely about not thinking like a nation state is supposed to think. So this is the starting point. This humiliation. Humiliation was always happening in the name of one simple recipient. That recipient is a person who can be left alone, living his or her own life in a language they want, in a kind of political sphere they want, whatever level they pick, and all around the territory of all the member states. This is the added value of the union. This is a score. The Court of Justice has been very active protecting the citizens against any kind of thick claims of the member states. And we're all aware of Micheletti case law, where the Court of Justice took an Argentinian with an Italian passport who has never visited Italy, who got the passport in Buenos Aires, and protected that person as a recipient of EU level rights from the claims of the Spanish state that his nationality somehow was fake. The same we all heard about Zhu and Chen, a baby born in Northern Ireland, precisely in order to acquire Irish Republican citizenship, was proclaimed to be getting born in abuse of law somehow by the British government. And the court disagreed. The court said you cannot be born in abuse of law. And by the way, if you are born as an Irish citizen in the British territory, it means that you're exercising your free movement rights. It means that you should be protected from any kind of claims, identitarian claims, coming either from Ireland or from the UK. And by the way, your mother can stay with you. So then all the case law can be read in this way. This is the starting promise. And this all changes 10, 15 years ago, when the Court of Justice starts giving signals to the minorities in the member states that actually it will prefer the official story of the national history, not the story which those minorities know. So if you are a Polish minority member in Lithuania, then the Court of Justice will tell you, you have used your free movement rights, you want to rely on EU law, you want to claim protection compared with all the other EU citizens moving freely. Obviously, you're a worker, but you have no rights. Because you claim to be Lithuanian, you claim to speak the language which officially doesn't exist in the state where you return to get married. This is all real case law. In fact, you even spell your name using the letters, namely W, which don't exist in the only official language of the member state. So you should correct your ways. You should come to terms with the fact that in the eyes of the Lithuanian state, you are somehow deficient, and we agree with the Lithuanian state. So this kind of case law was a shy beginning in opposition to Gareth Davis's initial accumulation of the state as a constitutional tactic framing. And then 5 years ago, we have a boom of Tiebes when the Court of Justice says the Dutch law that says that you are not Dutch anymore if you live abroad and you fail to renew your passport once. That's it. Ex lege, you are not Dutch anymore. You cannot restore it. You cannot renew it. You have no connection with the European Union, with the Netherlands. the Court of Justice says, in principle, this stands. So there is a full U-turn. The Court of Justice, who was humiliating the member states and took the side of the human being as opposed to this petty nationalist narratives, and that's how member states perpetuate themselves, petty nationalist narratives. This is the bread and butter of statehood. Nothing's wrong with that. The good thing was that the European Union was not taking that path, and suddenly it has changed its mind. And so, to me, Commission versus Malta, where the Court of Justice goes, well, it doesn't even bring up any of the arguments which the Commission listed, because the Commission listed genuine links, the Commission listed some general principles which don't know such specific application. The Court invents its own principle, which is solidarity, and then it puts it on its head, just like it has put on its head all of its citizenship law that the citizenship scholars admired so much, non-nationalist citizenship scholars. And it does a simple thing. It says, instead of being a union which is based on the solidarity in the name of precisely liberating the citizens from this kind of petty claims and denying them protection of EU law, the union is now something different. The union is now protecting those nationalist claims, and even like in Runevich-Vavdrin, like in Tebis case law, but now it comes on steroids. So Runevich on steroids. Runevich is that case where a Lithuanian citizen, Polish minority lady, takes her Polish lover back to her homeland, Lithuania, the country which was, when Stalin occupied it, it decided that it needed some of Polish territory, and he made that Polish territory their capital. So they're from there. And the Court of Justice says, actually, you shouldn't exist as a people. You don't have any claims at the individual level. So the European law is not on your side. And then the Lithuanian authorities issue them with a marriage certificate, spelling their common name differently in order to accommodate the absurd claim of the Lithuanian government. So where are the steroids? The steroids are quite funny. The Court of Justice said, even though we don't have the competence to decide on these matters, obviously, given that EU citizenship is so important, we will decide who is the real EU citizen. It will not be Malta, it will not be France, it will not be Lithuania. We will decide retroactively based on non-disclosed conditions who has a real attachment to a member state, who has bought what, and who has been transparent enough in order to acquire the citizenship in a lawful way in our understanding. A reminder, they shouldn't have such an understanding at all if you study the case law where they started. So now, surprise, surprise, the legal connection between the individual and the state, which is citizenship, is for the first time interpreted by the Court of Justice as insufficient to make a citizen. Someone naturalizes you, and then Micheletti comes back in a nightmare. Although you have all your documents, somehow you're not good enough. Your Greek blood is preferred, or an undisclosed payment to the Austrian authorities. This is something that is okay. But a transparent system of citizenship acquisition based on investment is not. And why? We don't know, because the Court of Justice has never specified. So to me, it doesn't matter what the Court of Justice takes as a pretext. Selling, non-selling, what matters is that there is now a full circle from attacking the state in the name of the rights of the citizen. The Court of Justice came to attack the citizen in the name of petty state-like claims, which it upgraded to the supranational level. So now there is a supranationalist nationalism in the European Union, and that nationalism implies that you should not sell the sacred right of belonging to the Union of the 27. This is a very, very sad development, and it's in particular sad because now nobody's safe. All of us can be next if we have EU passports, because because the Court of Justice could follow more national narratives. When the Portuguese gave to Abramovich his Portuguese citizenship, Mr. Abramovich is from part of his family was Sephardic family. Immediately, politicians shout, "Oh, that's a wrong Jew. This is not the Jew we had in mind when we installed this kind of system. So let's purge our citizenship of the wrong Jews. He should be deprived. He should be stripped of Portuguese citizenship." There are plenty of other magnificent examples. Think about Baryshnikov, a great American dancer, who also was a great Soviet dancer, who was also a great dancer from Riga. If you know about citizenship law of the Baltic states, especially Riga, this is it's not quite an apartheid regime, but very close. The whole state is designed to deny a huge share of its population any kind of rights and any kind of equality claims, because it's designed not for itself, but against them. And Baryshnikov is them. So then once he becomes a world famous dancer, they invite him, and then the same as whatever the parliament is called, where half of the population is represented, passes the law saying, let's grant citizenship to Mr. Baryshnikov because he's such a great American dancer. And by the way, he was born here. I can imagine how this can be read by the Court of Justice now. What are the ties of Mr. Baryshnikov, a former Soviet citizen who is now an American dancer, to the member state of the European Union, which we know as the Latvian Republic? It could be none. And we just opened the Pandora's box. Once you pretend that a legal status is not a legal status, well, you run into trouble. The European Union was designed to oppose petty nationalisms, and now it's basically enters the stage all in feathers and in bizarre drag, telling us, I'm your new nationalist story. The trouble is nobody believes it. But that's another matter. So we are entering the troublesome time for those who believe that European citizens should be entitled to some kind of rights also when they don't buy the official narratives. And I probably stop here.
Thank you.
Thank you so much. Thank you, Claudia. Thank you, Colm, as well. I think he's online, and Kat for organizing this event. I'm delighted to be here. I might disappoint, but I won't speak about the judgment either. I will speak about residency by investment program and citizenship by investment program. But in fact, I'm kind of interested in taking a step back. I'm interested in the questions of merit and the interaction with race, and how this interplay in the context of residency by investment program and citizenship by investment program. And I would like to review now that, in fact, the citizenship by investment program and residency by investment programs are just the wrong targets. And we need to basically redefine the debate about this issue regarding CBN and RBI, and rather try to think about how dismantling the structure of racial stratification behind EU migration law. So this is what I would like to propose. So first, I will say a few words about EU migration governance and merit. Second, I will try to convince you that actually this merit-based system is actually undergirded or based on race and is like strongly ingrained in racial components. And then I will come to the final argument, basically arguing that we are missing the target here. So it's kind of interesting because for 20 years now, we have increasing literature explaining that now we have kind of a move from a selection based on origin towards a selection based on merits regarding the EU migration system. And the literature is right, like we have Hinder Haas based on quantitative research and on statistics and figures showing that, yeah, increasingly like migration is about merit. We also have Ayat Shakar saying that merits kind of supplemented a selection by origin, and Jopke also speaking of immigration policies based on neoliberal nationalism, speaking of them being ethnically anonymous. So first, we need to come back to this term merit, because merit can encompass like anything, you will tell me. But in the context of EU migration, it's kind of straightforward. Merit is about skills, talent, and effort. But merit is also about money. And there is a very interesting article by Odile Mann arguing that CBI and RBI are actually, which is in the book, by the way, yeah, which is in the book, so a way to promote the book, are actually about merit, and that the distinction, I'm quoting her, between capital to court and human capital is not watertight. And indeed, capital can be the fruit of a person's merit. And it's kind of interesting because now the industry of RBI and CBI has just rebranding this citizenship by investment program and residency by investment program as basically residency by merit program and citizenship by merit program. So we really see here that there is something going on here with this concept of merit. And when looking at the law, we indeed see like the words and the EU instrument, and even the instrument like adopted by member states. We have all this, of course, like RBR program, but we also have migration program based on skill. Increasingly, we see the EU Commission insisting on the importance of skills, talent, to try to attract them to the EU. But we also see this idea of merit being introduced in a much more subtle way. For instance, we have all these so-called integration tests, which are imposed on third country nationals. And third country nationals have to demonstrate that they are not demeritorious, or at least potentially, or even like potentially meritorious, by taking this integration test. This integration test, you have to basically perform something, right? You have to pass something. If you fail, you can basically not get a family reunification visa. You can be fined. You can basically not get some housing benefits even. So there is this idea of performance between this integration test, which most of the time imply like language test and knowledge of the country test, right? And then you also have what Natalie Welfens has called promising victimhood, which concern like the issue of resettlement regarding refugees, where refugees don't only have to show that they are vulnerable, but that they are ready and eager to overcome their vulnerability to become potentially meritorious, which is also a kind of interesting concept showing the importance of merit, not only like through these kind of highly skilled profiles, but also like towards like migrants, which might not be seen and perceived at first sight as a meritorious. But then we are here facing a kind of a paradox, right? Because we have this increasingly model of merit-based model of selection towards migrants. But when we look at the figures, or when we look at another strand of the literature, we still see that EU migration law is mainly ingrained in origin and race. Like all these people dying in the Mediterranean, more than 30,000 people, come all from sub-Saharan Africa, right? Like we all the pushback at the Belarusian border, like we speak about like people who come from the Middle East and also from Africa. And so we have this kind of tension thinking that, oh God, yeah, on paper, indeed, it's about merit, but at the border, it's not that much about merit. So how to reconcile this paradox? I'm arguing that actually merit is undergraded by origin and racial hierarchies. So first, I think one of the most obvious example is about this integration test. So I said and explained that these integration tests are fundamentally in a way about merit. And when you look at who has to pass and to take this integration test, these are in many member states, non-Western migrants. So in Germany and in the Netherlands, like in order to get the family reunification visa, only non-Western migrants have to pass this so-called integration test. Western migrants, including Canadian, Americans, Japanese, don't have to take this test, right? So we have a dimension of merit, but behind it we see like this kind of a racial and origin dimension. And then we have, when we look at also how skills are appreciated for migrants and work, there is in a way, like in a way, merit and skill are appreciated and evaluated very differently depending on race. And there is a lot of research based on that. There are many figures showing that basically migrants tend to be overqualified, and especially like so-called racialized migrants tend to be overqualified for the job they have. And then you could tell me, yeah, but let's look at the figures. Let's look at the figures. And for instance, for 2023 on Eurostat, you can see that how highly skilled migrants, blue card directive, 89,000 people got a blue card, highly skilled blue card. These people, by the way, are exempted to take integration tests, which is kind of very interesting. And who are these people? Like in the top 3, Indians, Russians, and Turks. So if you want, your skills, your merits is a way to overcome and to offset, if you want, this integration imposition and the fact that you are perceived at first sight as being meritorious. And you can say, no, in fact, I have highly skilled and I don't have to basically take these integration exams. The same for intra-corporate transfer. Indian, Chinese, and South Korean are in the top 3. But when you look at the 1.3 million of work-based residence permit, Russians and Ukrainians come first, and then like in the low-skilled sectors, like Moroccans, people from Bangladesh and India are like basically in the top 3. So why I'm basically taking all these statistics is that we see that non-Western, that the group I call like racialized others, in a sense, some of them manage to, the system is porous enough for some of them to get into it. But this is still a very tiny minority when we look at the total, when we look at the figures, and that among them, there is no people coming from sub-Saharan Africa as well. So there is what I call, and this is all a call in progress, but also a kind of a hierarchy like within these racialized others. RBI, it's the same. When we look at the figures of RBI, of residency by investment program, citizenship by investment program, who benefits from it mainly, these are Russians, I mean, used to be Russians and Chinese. So there is a kind, so merits like has definitely, is undergirded by origin and then therefore by race and ethnic origin. And there is this also this idea that each individual has the responsibility to overcome their bad passport, to overcome basically their difficult situation due to their bad passport. So now coming back to to residency by investment program and why we basically are focusing on the wrong targets. The first reason is more egalitarian, and it's kind of interesting because all the opponents of like the opponent of the program, citizenship by investment program and residency by investment program, like some of them like use some kind of egalitarian kind of argument. Oh, but these are the rich, they are coming here, and how about the poor, right? And I'm actually like saying that if we actually take the perspective of an egalitarian perspective, and if we really care about equality and dismantling hierarchies, and especially racial hierarchies, we need to speak about like what Dimitri has called the citizenship apartheid system. The fact that citizenship is one of the main elements nowadays at a global level, which plays within like the inequality system, the economic inequality system. This is Branko Milanovic, which explains that very powerfully. And so we need basically to question the system of passport apartheid instead of focusing on these very few people who get a passport because they are rich. And an egalitarian actually might want to defend them because, in fact, there are less people coming in if we oppose the program, rather than if we just say, okay, the program is there, let's let them in, and maybe think about a more egalitarian kind of system to regarding this passport apartheid. And I'm finishing with the 3 points, which are going to be shorter. There is also the question, the utilitarian reason. So this kind of question of economic added value. If you want people to be perceived as being useful for the society, and I think that this is also one of the arguments that Lior made, like these programs tend to benefit the society in terms of economic added value even more than workers in themselves, and they are as racialized as the basically works program. So here, either we want migration to be an added value for the society, economically speaking, or we don't want, but either we exclude all of the programs, including highly skilled, or we include all the programs in terms of the utility for the society and the economic added value. And then there is, of course, the question of Republican citizenship, that one kind of link we want people with the society they are in. Then we need to have a real conversation about then what about blood, right? What about blood? If money is not a link, some people just get the citizenship because of their ancestry, having never lived in the country. So here we need to have a real debate about what kind of society we want and what kind of citizen we want, instead of just excluding people who pay for a passport. And I think we need to have a debate about that instead of just excluding this very tiny proportion of people benefiting from a passport because they pay for it. Then we could have the same debate about blood, because admitting that we can let people in just for their blood and not because they paid, and there is again a kind of a racial kind of underpinning dimension here. And then also, I think it's important, and I'm finishing here, the question of the post-colonial kind of aspect of the citizenship, which is extremely important. And Manuela Boatka also wrote a very good paper, not in this book, but in another book Dimitri edited. And so just reminding that citizenship is a tool which was used to undermine the colonized, and that investment migration cannot be separated from citizenship past as a colonial tool of racial domination, basically, and that if it's basically a very scarce resource is because of this kind of colonial past, or what Manuela Boatka has called the coloniality of citizenship. So again, here, instead of just focusing against the program, let's have a debate about what citizenship is about, and basically the coloniality of citizenship, another target that we need here. So I hope that, sorry, I was maybe a bit too long, but I convince you that let's drop this debate about citizenship and investment. I mean, this is a secondary, besides all this important question that we need to have citizenship scholars, but also as a society, what kind of citizens we want, what is citizenship, do we want to basically overcome the global racial hierarchy, and the institution of citizenship, which is itself a colonial. So thank you for your attention, and I'm gonna give you the floor, Oliver.
Thank you, Sarah. Oliver Gerstenberg.
Good, thank you, Claudia. I will want to come back to the judgment a little bit, and I disagree with much of the criticism which has been leveled against the ruling, including with Dimitri, and I would like to defend the Grand Chamber's ruling. I believe that the court could not possibly have decided otherwise than it did, and therefore also reject the characterization of the ruling as judicially activist. Indeed, I believe it is a textualist judgment. So now, before I start, I was wondering how familiar are you guys with the judgments? How familiar are you with the facts of the judgments? I mean, I have not prepared that as part of my talk, but I think it would be useful if you have these facts. Do you know the facts? Silence. Well, I will give you some of the facts, just in a nutshell. So you can buy, or you could buy, Maltese citizenship for a contribution of 750,000 euros to the Maltese government. Plus, you have to purchase residential property with a minimum value of 700,000, or alternatively, the lease of such property for an annual rent of at least 16,000 for a minimum period of 5 years. Thirdly, a donation of at least 10,000 to a philanthropic, cultural, etc., non-governmental associations. And fourthly, legal residence in Malta for a period of 36 months, it being specified that the period may be reduced to 12 months if the applicant makes an additional contribution to 150,000 euro. And but these, as the file further explains, these essentially there is no hard residence requirement. This was pitched as access not just to Malta, obviously, but to the EU as such, for your family and for everybody. So, and it was through private agents. It was sold. So that roughly is the background. We can say more about it afterwards, because that was not the focus of my talk. So the importance of that ruling lies in the clarification that union citizenship is based on common values contained in Article 2 of the CJEU. Now, I don't know whether you know that provision. It says the union is founded on values of respect for human dignity, freedom, democracy, equality, rule of law, respect for human rights, including persons belonging to minorities. These values are common to the member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. And Article 2, as you know, is the focal point of mutual trust in the EU, mutual trust between the member states as regards, in particular here, the fact that no member state can exercise their sovereign powers to lay down the conditions for granting the nationality of a member state in a way that is manifestly incompatible with the very nature of EU citizenship. So in essence, what the court is saying here is Malta was trying to sell something, EU citizenship and its benefits, which did not belong to Malta, at least not exclusively, because EU citizenship belongs to all of us as EU members, as EU citizens. It's a common achievement of ours, brought about through collaboration, and brought about. It is a common public good which we all share as we collaborate as EU citizens. So that cannot be disposed of unilaterally. You cannot transfer to another more rights than you have. Unilateral disposition over citizenship, EU citizenship, would violate the Kantian categorical imperative. It would treat other member states and their population as means to an end, and thus not be within the EU universalizable. So that is the core of that is the gist of the judgment. You cannot transfer something that you do not have because it's a collective good. And I will now spell that out a little bit. First, the idea of collective achievement, and secondly, the idea of solidarity. And also, I would like to push back against the title of our very own event, because I do not believe that solidarity and liberalism are opposites, but I believe that properly understood, they go hand in hand. So we should not be trapped by false premises here. Good. So starting with the idea of the EU as a collective achievement, let me hark back to something, to a previous debate, namely the concern with sovereignty, which underlies this discussion. I mean, to grant citizenship is a core of national sovereignty, as you know. That concern arose already in a different context, namely in the rule of law context, when it was in the debate on judicial independence. And here, the court overcame that competence anxiety, if you will, by linking judicial independence to the internal market. So the very essence of the internal market is grounded in free movement, which requires the effective judicial protection of economic freedoms against protectionist measures, since free movers do not in principle enjoy political representation in the host member state. Upholding the rights may require access to a court of law. So there is a representation reinforcing rationale behind that, and already there emerges a link between the rule of law, democracy, and citizenship, and that is encapsulated by the formulation which the court uses in all these contexts, namely the identity of the European Union as a specific legal system. So these are formulations used in the rule of law context and in this present decision. So the background story, I don't know, again, how familiar you are with this. Perhaps Claudia will permit me just to say a few words on this. So it started off with the Commission complaining about this Maltese program and engaging in a reasoned dialogue with, and under the proper procedures with Malta, essentially alleging the following, or arguing the following, that although it is clear that the member states have the exclusive competence here to act when it comes to citizenship, the exercise of that competence has consequences for EU law, and namely concerning the essence, value, and integrity of union citizenship. And apart from the economic aspect, the Commission emphasized the strong civic component of that, bringing together the peoples of the member states, and also that the EU is not only an economic union, but also a political union. And so agreement by each member state to extend automatically certain rights to the nationals of all other member states in line with the principle of mutual trust is premised on the understanding that these other member states only award nationality on the basis of a genuine link with the applicant concerned. That was the case by the Commission. Now, the Advocate General Collins demolished that claim by saying two things. First of all, there is no genuine link requirement in EU law. Member states can have that of their own, but it is not required neither by EU law nor by international law. And besides, Collins spoke of, the Advocate General spoke of the risk of a wholly unlawful erosion of the member states' competence in a highly sensitive field where member states should remain exclusive control. That was the position of the Advocate General. Now, the court did not at all follow Collins, but as we shall see, it created its own categories, because it is true that genuine link is not a requirement. So the court developed its own conception here. But so the court here first started with a very textual analysis. The core argument is that there is an infringement of Article 20, which, as you know, establishes the EU citizenship and says that everyone holding the nationality of a member state shall be an EU citizen, and that EU citizenship is additional to and does not replace national membership. and Article 4.3, which enshrines the principle of sincere cooperation. So that is the normative benchmark that was, according to the court, violated. About the meaning of citizenship, first, there is the internal market rationale, which is similar to what we had in the rule of law debate, namely, the EU offers its citizens an area of freedom, security, and justice without internal frontiers, in which free movement of persons is ensured. So that is familiar stuff. But the court also shares, and by way of textual analysis, the idea that there is a civic rationale, that democracy is a value. And by saying citizens have political rights which ensure their participation in the democratic life of the Union, and that is all Article 10, Article 11 of the TEU, and the idea of representative democracy. And from that, the court moves on to what is one of the core statements here, that Union citizenship is thus one of the principal concrete expressions of the solidarity, which forms the very basis of the process of integration, that is the raison d'être of the European Union itself, and thus form an integral part of its constitutional framework. And speaks in this connection also of the of the identity of the European Union. And importantly, of course, the court says what I mentioned already before: Union citizenship is based on the common values contained in Article 2 and on the mutual trust between the member states as regards to what member states do concerning the citizenship, EU citizenship. So Article 2 is absolutely central here. And then the court continues, in that regard, it is clear from the court-settled case law that the bedrock of the bond of nationality of a member state is formed by the special relationship of solidarity and good faith between that state and its nationals, and the reciprocity of rights and duties. No more, no less than that. So solidarity figures twice here at the EU level, the reference being the process of integration, that is the raison d'être of the EU itself, and secondly, at the national level, concerning this formulation, the special relationship of solidarity and good faith between that state and its nationals, and the reciprocity of rights and duties. And both these levels are infused with Article 2 values. And that forms part and parcel of the idea of mutual trust we have as member states to each other. And also in this connection, the court emphasizes the idea of the EU as a joint venture, an enterprise of the member states and the EU in creating the fundamental status of nationals of the member states. So that formula is often criticized, but the point is that this is a point of overlap between the member states, and in that sense, it is a fundamental status. Good. And the court then goes on to say that this is this idea of EU citizenship, so not citizenship as such, not national citizenship, but EU citizenship as a joint enterprise cannot be unilaterally sold off. So it is the unilateral action which would violate the idea of EU citizenship as a common enterprise, because we have not been asked, we others. Yeah. So, and it would violate what I call the Kantian categorical impact. Good. The court spells that out. You can be critical of the formulations. I mean, I haven't counted so many times the court used transaction and commercialization and
I used 8.
What is it?
8, including.
No, it's more. It's far more. It's far more than that, actually.
I use the
more
automatic. Word.
So it is very, very often you can see that. But that is the core of the judgment, its rationale. And I will then, in a second part, concluding, say a few words about solidarity. There's absolutely nothing in the court's formulation of a special relationship of solidarity and good faith that conceivably supports an ethno-nationalist reading of solidarity. Instead, it is, as I mentioned before, an idea of, I mean, we could imagine different models of a polity. We could say that we could think of a polity as based on a de facto accident of history and geography. We could think of a polity as a common commercial enterprise. And thirdly, we could think of a polity as ruled by common principles, not just by rules and outcomes of a political compromise. And that clearly is the idea here to which the court is alluding. And so to conclude, let me just say two things. The idea of a joint enterprise, citizens of their respective member states through their national governments and parliaments have commonly agreed on treaties by means of which they are constituted, and the EU as a supranational political entity. So it is a project that initiates from you and me as EU citizens, and not something that can be unilaterally appropriated. So that is the idea of a collective good. And more speculatively, I would say, where you may ask, wherein lies the importance of such a ruling which has a moral character? The idea here is, and I'm speculating, I mean, these are questions that can be controversial, is that the court is turning political decisions which are expressed in the treaties, in the directives, in regulation, and secondary law, into principles by insight into their importance. And in a changing geopolitical context, these principles, which initially started off domestically in the member states, are effectively best defended and kept alive and vibrant at the EU level. So the EU presents itself as a polity in a changing global context where such values, namely Article 2 values, which are the EU's principle of legitimacy, can be defended. The EU stands for these values globally, and in this way differs from other polities we can see around the globe. This would be vitiated, however, through such a program. Thank you.
Thanks a lot, Oliver. Leo.
Okay, so thank you, first of all, to the organizers for inviting me to contribute. So I think, as Claudia mentioned before, I'm a bit of an outsider to this debate, as I'm not a legal scholar. I'm a normative political theorist working on the political ethics of citizenship. So I'm not going to comment on whether this ruling is an act of judicial activism or whether it's it has textual basis. Nor am I going to say anything about legal competence or issues like that. And even more disappointingly, I'm going to offer a very maybe disappointing middle ground between the positions presented here so far. What I want to do in the time that I have is to offer some broader conceptual reflections on the state's right to grant citizenship and the limits on this right. And I'm going to draw on the normative political theory literature, both from my own work and from others. But I do hope that this will serve some useful purpose as an intervention to the legal discussion of this particular ruling. So from the perspective of normative political theory, investment citizenship presents an interesting puzzle. And this is for two reasons. First, in most of the literature, the question of citizenship policy is almost always linked and is a subset of questions about the ethics of immigration policy.
And the assumption is that when state grants citizenship, it always is followed. It follows territorial admission and long-term residence. And citizenship by investment practices, and especially ones like Malta that require no or minimal physical residence, they're beyond the scope of this literature. Secondly, with regards to the state's power to determine membership, the focus of the literature has, understandably, given the stakes, has been focused on the limits on the right to exclude individuals from citizenship. So again, asking whether states should be obligated, for example, to offer a path to citizenship to people who are long-term residents or have family ties, or people who would otherwise lack legal or effective citizenship would be stateless. But citizenship by investment policies, on the other hand, they don't deprive any individual of rights. Instead, they offer citizenship to those individuals that don't have a prior claim to it. So from the point of view of the literature of normative political theory, it's really unclear what the problem actually is. And this is why I think that we need to shift our focus from the right to exclude and its limits to thinking about the right to include, whether the state has a right to include new members that don't have a claim to citizenship, and then what is the limit? What are the limits to this right? Now, I find it illuminating, and I'll link back now to the ruling and the legal discussion, that in its argument, the Commission has actually employed a similar tactic to several normative theorists, notably Ayelet Shachar, who's already been mentioned here before by Sar. Shachar famously criticizes what she calls the birthright lottery of existing citizenship practices, and she wants to offer a different normative principle according to which citizenship should be allocated, which she called jus nexi, and this is like the guiding light of citizenship distribution in her view. Notably, and this is the move performed in the ruling as well, Shachar conceives jus nexi not just as a sufficient condition for citizenship, that is, if you have this kind of social connection, your right to citizenship is triggered. She also thinks that this is a necessary one. So if you don't have a social connection to the polity, this obligates the state not to grant you citizenship. So this is both a limit for under-inclusion and for over-inclusion. Now, in previous work, again, in the other book that Dimitri edited on this topic, I've been critical of this move because, not least because, like the ruling before us, it fails to provide justification as to why citizenship by investment should be singled out as normatively problematic, as opposed to other presumably over-inclusive policies that don't align with jus nexi. And critics of investment citizenship, including notably the Commission, sometimes try to solve this problem by appealing to some intrinsic features of the institution of citizenship as such, usually following anti-commodification arguments that normally in the literature apply to things like bodily organs or sex work as things that shouldn't be for sale, and arguing that citizenship, or at the very least, I think as Oliver suggested, European citizenship cannot be sold. Again, that's a very Kantian argument. And this kind of intrinsic argument is notably different from more contingent argument that point to the harmful effects, say, of selling citizenship or corruption or the involvement of private firms in the deliberation process of how these policies are accepted or promoted, because they want to say that this is an argument against the commodification of citizenship as such. Now, in my own work, I argued against these kind of intrinsic limits on the state's right to include in cases of citizenship by investment and elsewhere, because I view these as a distraction. Instead, I argue that we need to focus on external constraints on the state's right to determine its own membership policy in cases in which overly permissive citizenship policies by states generate adverse effects to their own members and to third parties, be it individuals or other states. This is a more promising route in my mind because it preserves the justified rejection of arbitrary and unjust act of citizenship deprivation and exclusion, which are now constrained not by some intrinsic nature of citizenship, but by, for example, human rights considerations, but also allowing for a broad scope of permissible policies of inclusion by self-determining polities. So there's an asymmetry, in my view, between the limits on exclusion and the limits on inclusion. And I'm speaking again from the moral point of view, not from the legal one. The state is obligated to include all of those that have a claim to citizenship, but otherwise it's permitted to include others that don't have a prior claim based on other considerations. And it could be special contributions, like Sam mentioned, or merit, or reparation for historical injustice, like in the case of Spain and Portugal, etc. So in this regard, and this is where I think I stand in the middle ground between the contributions so far, I think the court's decision made a step, albeit a small step, in the right direction. Because unlike the commission's justification, the appeal here is not directly to the uncommodifiable nature of citizenship as such, but instead to an instrumental argument about the likely effects of this policy, the implication of such policies on other member states, and for the union as a whole. So while I agree with many of the critics of the decision that the substantive argument provided by the ruling is somewhat lacking in justification, I think it's at the very least of the right structure of argument that we need in order to rule out certain policies of citizenship by investment. In an article by that I wrote with Ayel Banai a few years ago, we argue that actually the value of self-determination itself, which is what grounds the state's right to grant citizenship, can be self-limiting in cases where over-inclusion undermines other states' equal right to self-determination. So in that sense, it doesn't violate the categorical imperative that Oliver mentioned. So within the framework of the European constitutional order and the rights accompanying shared European citizenship, this kind of argument, I think, has some force. Now, as I said, even though I'm favorable to the structure of the argument, I'm more skeptical of the substance of the argument provided by the court. So I'm not going to go into detail like Oliver did, but I want to offer, from a legal perspective, an amateur reconstruction of the argument and to point where I think it fails. So really the core of the argument is in paragraphs 94 to 100 in the decision. And here's the argument as I think the court is trying to structure it. First, the argument is that the principle of sincere cooperation requires that states do not jeopardize the attainment of the European Union's objective. That's, I guess, uncontroversial. Then the second step of the argument is to say specifically that the power to lay down rules on the acquisition of nationality may not be exercised in a way that is manifestly incompatible with the very nature of union citizenship. Now, this could be interpreted in an intrinsic way, but we could maybe charitably say this is just a special case of the previous statement, right? So they shouldn't operate in any way that jeopardize the objectives of the union. And this is a special case regarding the citizenship policies. Here's where the tricky bit comes in. So in paragraph 96, court says, the bedrock of the bond of nationality of a member state is formed by the special relationship of solidarity and good faith between the state and its nationals and the reciprocity of rights and duties. Now, suddenly here, there's a comment about the normative foundation of nationality that didn't appear before, and not as a sufficient condition, again, like I mentioned earlier, but as a necessary one in order to be a national of a member state. And then the next step is to complete the attack on citizenship by investment. The court says, a member state manifestly disregards the requirement of such a special relationship of solidarity and good faith, characterized by the reciprocity of rights and duties between member states and its nationals, thus breaks the mutual trust on which union citizenship is based, when it establishes and implements a naturalization scheme based on transactional procedure. And finally, and this is the final blow, because member states must recognize the effects of each other's nationality decisions, transactional naturalization is liable by its nature to call into question the mutual trust which underlies these the requirement of mutual recognition. So something went wrong in this argument, right? Even though the structure of the argument is the one that I favor, of an external constraints based on the effect that one polity's laws regarding citizenship and naturalization would have on other polities, and again, in the European Union, probably is stronger than if we think about this globally. It sneaks in a substantive internal constraints about the necessary conditions of granting national citizenship. This is paragraph 100. But these are two separate kinds of arguments, and I think it's best if we keep them analytically separate. I think the court either has to show that citizenship by investment violates this internal condition of what is required in order to be a national member, but that really does look like genuine link in just using other words, right? We're just thinking in the genuine link again, which has, as the lawyers in the room would say, has very flimsy legal basis, but also from a normative perspective would raise issues. Or the more promising route to show that there's something about the transactional nature of citizenship by investment that is uniquely problematic for mutual trust. Olga mentioned this being a unilateral move, but many citizenship policies are unilateral. There's nothing specific about selling citizenship that's uniquely unilateral, or at least we don't know what this argument is. So I think this latter move is the more promising one. And again, this is a legal text and not a philosophical one. If it were a philosophical one, I, as a referee of the argument, would ask if they can clarify how exactly citizenship by investment is unique in this regard of violating the mutual trust required to attain the objectives of the union. Thank you.
Thank you. Yes, I'm also not a lawyer. I look at this much more from a policy perspective. So they can do these programs, why do we have these programs and do they work? And one of the things that I find really interesting about the legal and normative debate about this is you often get these prostitution metaphors, right? This idea that there's this wonderfully valuable thing that we shouldn't actually be selling, but we do it because the money is so enticing. And behind this, and the thing that no one really questions is actually, are these programs economically beneficial at all? And I actually think that the benefits are overstated. That actually it's not obvious that that residence and citizenship by investment programs are economically beneficial. Now, let me unpack that a little bit. So there are lots of different types of programs. Particularly looking at residents, most of them facilitate some kind of private sector investment, often, investing in a private business, sometimes in real estate. So does that money have economic benefits? I think actually a lot of that investment is just displacing other investment that would have happened anyway. A lot of the investors are gravitating to the most attractive low-risk investments that actually don't have too much trouble attracting funding. Anyway, it is very difficult to make to basically force people through the immigration system to invest in stuff that is such a bad investment it would not otherwise have received funding, right? And that's because the immigration system, people are investing not because it's a good idea to invest in it, but because the immigration system told them to. There's a separate question, okay, what about the people who arrive under this program? Do they bring benefits? Here, I think it's very difficult, and I don't want to sort of generalize too much across different countries, and the profile of people who move is going to be very different, or move or indeed don't move, because many of them never move to the country of destination, the country issuing them the status. But there's this kind of vision that we're going to bring in these kind of exciting captains of industry who will set up businesses. And in many cases, the typical applicant to many of these programs is the wealthy housewife of a rich person who's made a lot of money in Russia or China or other parts of the world, doesn't necessarily want to move themselves, but they send their wife and children across. Now, there's a legitimate conversation to be had about, do countries want those people or not? But I think all I'm pointing out is that there is a discrepancy between what policymakers often think they're getting in these programs and the people that they actually get. So I think, Sarah mentioned this question, you raised this question, do we have the wrong target with these programs? I think in many cases, in many countries, it may be the right target, but not for those reasons, just because they're often actually not very economically beneficial. One exception here, though, which is where we get to the Malta case, is if you just accept cash, right, then all of those problems about trying to push people towards the most beneficial investments, that gets less complicated because, you know, this money is real, you can decide what to spend it on. Right now, I think that actually that's not a slam dunk argument for all countries. I think that it works particularly in quite small countries where the amount of money we're talking about is really appreciable. I think that in bigger countries like the UK, I think I'm quite skeptical that even selling citizenship or resident status would be particularly economically useful. The programs do have drawbacks as well. It is no secret that not everyone who comes under investor programs is squeaky clean. The UK had some genuine problems with this. Due diligence is really hard. So I think there's an argument for many, legitimate argument as well for many countries that these programs are basically just more trouble than they're worth. However, if you put aside that issue around the due diligence, I think we've had this sort of trade-off, right? Which is that the policy model that is most economically beneficial, i.e. just accepting cash, is the one that is most distasteful to the average person on the street. And so here Malta was this kind of interesting exception because it was very unusual as being a high income country that had the nerve to just accept cash, where I think most of the policymakers don't dare. Now, I should be clear, I'm not saying that I think countries ought to sell their citizenship or visas. There are perfectly respectable reasons not to do that. But it is interesting. And I did some, so let me just finish with a postscript on Trump and the Trump card with his picture on the front and yeah, beautiful looking thing. I did some research a few years ago when I interviewed British and American policymakers about their residence by investment programs, both of which were based on private sector investments. And I asked them about, well, have you thought about just selling this? You know, what do you think about that idea? And actually in the UK, this had been proposed by the Migration Advisory Committee. I'm in the interest of disclosure, I'm on that committee now. I was not on it at the time that it proposed. It proposed actually something that's politically even worse than selling visas, which is auctioning visas literally to the highest bidder. Anyway, and I, you know, in the UK case, I asked people, and in fact, it said, no, this was never going to go. It's completely politically unthinkable that you could do this. I asked people and policymakers in the US, you know, what about the idea of this model? Some countries obviously just sell these, you know, either citizenship or resident status. And they were really nonplussed. Why are you even asking? This is just such an absurdity. There is no chance this would ever go anywhere. Anyway, they were slightly confused that I was even asking them the question. So I thought that was sort of entertaining that, you know, here we are just 3 years later, and it turns out politically it's not so impossible after all.
Okay.
Right. Great. As expected, we're running a bit behind time. So we don't have much time, but I suggest we have a quick fire round where each of you gets a chance to respond to each other, not more than 1 minute. So we have some time for questions, please, before we go over the drinks across the corner. So 1 minute.
Just a couple of, so a small story. I run the rule of law research group at the Democracy Institute, which is actually in Budapest. The university was kicked out, but we stayed in Budapest. So we host fellows from all over the world, and we hosted plenty of Brazilians. And suddenly there is a Brazilian coming, quite a competent Brazilian, SJD from Yale Law School, etc. So a great guy. And he contacts our administrative support team saying, I will need a visa to stay in Hungary. And everybody's shocked. What kind of a Brazilian have you found? This is totally insane. Is he black or what? And in fact, this is true. So all the other Brazilians, dozens of them we hosted, all had Spanish, Portuguese, Italian, Greek, Irish, and other passports. And finally, the most meritorious Brazilian doesn't have the right to be present in Hungary. And I'm telling this to come to unilateralism. Was he made Italian by a collective decision of the EU to be racist, or not made Italian? Not at all. It was just as all citizenships are distributed unilaterally, he was made or not made in Italian rather as a result of this unilateral policy. It just shows how EU citizenship works. The majority of people we see who come from far away and who will be hosted by our institutions, at least that's the case in Budapest, are the guys who have some European passports because of their blood. Blood is never questioned as unilateral, as problematic, etc., because that's the ethno-nationalist core of European citizenship. And this is exactly something that the European Union was basically built to make irrelevant. So this is my idea of solidarity, I think, which flows from all the case law of the European Court of Justice. That is a solidarity that defends you from any kind of unilateralism arguments that anyone can field, that someone doesn't speak the right language, that someone doesn't have the right color of the eyes, etc. And then there is a country unilaterally deciding to make someone anti-European a Southern European, and this is a flawed argument. So then if you think that this is solidarity, then this is a solidarity against what the European Union is about. And the final footnote, final. When the European Union citizenship was negotiated, think about the Treaty of Maastricht, Ireland was selling hundreds of passports because this was one of the main ways of acquiring Irish citizenship. So if we go to the history of EU citizenship, to the history of EU values presume that member states are competent enough in order to decide who the citizens are. And the Court of Justice has turned its back on this with no arguments at all. Just bullshit. I turn to the philosophical scribbles of Mr. Frankfurter, and this kind of forgetfulness is damaging the arguments even further.
Right. Do you think we should take a round of questions from the audience? Because otherwise we won't have time, and then you can respond to each other and those questions. Great.
I question about the idea of merit.
Can you speak up, because then we can maybe do without the microphones.
My question about the issue of merit, or even like the link in general to a country. So, for example, I'm a Dutch citizen. I've never lived there. I've never spoken the language, and in fact, I wasn't even like registered until very recently as a citizen. So, for me, as a person who's never interacted with the country, or even I guess given a benefit.
You are next.
Yeah.
You are next, and this is exactly what the citizenship is.
Yeah.
What makes me different to the person who bought their passport? Let's say the government implemented the same program, because if anything, I would argue that person has given a perceived benefit to the people, whether or not we argue like if that actually does any benefit. They've given money at least. I've done nothing. And in fact, in 40, 50, 60 years' time, I can come to Holland and say, oh, I want a pension, and I can take that pension. So what makes me different? What makes me especially protected is my question. Yeah.
Thank you.
Right, I'm Bronwyn Manby. There were various accounts, but I've learned about nationality and citizenship. I'm interested in comment of anybody about the development that this represents in the strict rule that nationality is a matter of state sovereignty, and why actually should nationality be a matter of state sovereignty when, for example, racial discrimination and other matters is not permitted. And nationality is famously a way of disguising racial discrimination. We're just discriminating, we're allowed to discriminate between nationals and non-nationals, and that's all we're doing, nothing to see here. So does this CJEU decision lead us to a point where actually the European Union, assuming it's not captured by the Orbans of this world, can actually say there are some positive ways in which, in fact, you must respect the US mix. You must allow people. It's not there yet, and that could go in two ways. One, on just procedures. If people fulfill the requirements for naturalization, then it must be granted, unless there's some objective reason why not, as opposed to leaving people never able to naturalize, or children born in the country who have been there until they are 18 should be able to acquire citizenship at majority, for example. Because it's not nowhere near that yet, but does it open the door in that direction?
Thank you, Mandy.
I think this decision will have quite significant ramification in many areas which relate to the European Union as a future federation. It's a confederation right now. But let's not forget, as one of the gentlemen in the middle said, that the European Union is based on values. It's the values that are the basis for the law, for the rights. So the rights have to be in line with the values. So the court was right to imply that Article 2 of the European Union has a precedent over any other rights. That's the first thing. The second thing is, and the second question is perhaps theoretical, you may remember that we had Brexit, and during the Brexit campaign, the European Union, or some within the European Union, came with an idea that the British could become the European citizens. Now, this is a reverse situation, right? A country outside the European Union suddenly is given the right to be the European citizen. It's very much like the Malta case, but the reverse.
Thank you. And one more here.
I think this has been very interesting. I particularly loved the interaction between Professor Koshinov and Dr. Gerstenberg. I just think it's interesting you use the textual analysis. I just think that it is. I think the word judicial activism, when it comes to the court, sorry, just disclaimer, I also write on EU citizenship, is an alarm bell ringing, and maybe we could tone it down a bit by calling it purposive reading, if you want to call it that. But I think it's possible for there to be worlds in which textual reading and competence extension actually happen at the same time. You could use the Poland case to illustrate that point. I mean, you went to the rule of law case in Poland, but you can go as far back as the Gravier case on students to make the same point. But this is the court's teleological reasoning. If we take the word judicial activism out of it, this is what the court's been doing for a very, very long time. And thus, on one level, it's not a surprise. I think what I loved about what Dr. Sumption was suggesting is that the problem is that nationality definition itself is somewhat arbitrary. And in a world of arbitrary definitions, investment citizenship itself could be criticised or complimented depending on how you view it. But I certainly think that you could suggest that the court has been both textual and extending competence at the same time. I don't see those two things as mutually exclusive.
Thank you. I'm going to ask you in reverse order.
I'm going to leave this one to my more erudite opinions.
Thank you. Leo,
Yes.
you can pick either any of the questions or, but not all of them, please.
Thank you. Okay, so I think maybe I'll just limit my answer to one question in the back. I think this is spot on, because I think there's a tension, at least if we think about, as I want to think about, the normative foundation of this right to grant citizenship and where it lies exactly. And there are kind of competing notions here of whether we need to think of something like jus nexi or whatever normative principle of allocation we want to have. It could be nationalist or it could be anything else, but the important thing is this as a principle determining who is a citizen independently of the discretion of states. So that's kind of one prong. And then the other one is the one I favor, is to leave this kind of discretion based on the idea of the democratic self-determination, where each polity can shape. I think this is part of the reason why it's interesting to move away from looking at exclusion, because I think in those cases, the plausible versions of these two accounts would generate very similar conclusions. So both of them would say if a child is born in a country, live there, they have a right to citizenship. It's when we start to look at cases like citizenship by investment or other cases of these supposedly over-inclusive policies is where the difference comes to. So maybe this is related to the question from over there. If we now think that the EU is a form of federation, then the competence or the power to grant citizenship would move for the federal level as it does in other places, right? If not, and if we think that there are polities that are self-determining, in my view, they should maintain this kind of right to determine their own members within the limits that we just described.
Oliver.
Yeah, thank you. I mean, this is rich stuff, and I'm a slow thinker, so I will not say very much. But if we or whenever we collaborate, we by that very fact make each other vulnerable to each other. So cooperation requires that we share something in common. And in the EU context, the vulnerability is between the member states. So if you expand or extend the notion of citizenship, you make each other, you become mutually vulnerable. And so the importance is that you can trust each other if you mutually share certain principles. And these are the Article 2 values. And these Article 2 values define here everything. They are the organizing center of this judgment. So in response to Bronwyn, yes, I agree that nationality can be a form of racial discrimination, but the court here is explicit on these Article 2 values to exclude that possibility. And also with regard to Lior, I mean, I've read the Shahar article as well and her work, and I like it, but I try to avoid any nominalistic argument. It's a bit like this prostitution argument that there is an intrinsic value and that is being demolished. I try to avoid it. I try to present it in positivistic terms here by saying you should at least have asked the other member states. You need a consensus for that. If you want to monetize citizenship, you cannot do it unilaterally in the sense of not without asking the others to ensure that there is a shared consensus, a shared framework in the background.
Thank you. Just maybe to jump on this, because I mean, nationality acquisition is still a competence of member states, right? So why selling citizenship should like basically imply asking the other member states, and why just giving up citizenship based on ancestry doesn't require. So how far do we go in that reasoning? And I think that the court's reasoning in that sense is kind of dangerous, right? Because we can really like get to, even more racist kind of way of saying, okay, we will just like I don't know, it's to me like it's a way to go much further in restricting basically people who can get the EU citizenship, which is a privilege. So this is what we have to it's a privilege, and I don't think that we can speak of the policy here because we were not consulted for any other kind of way of
where do you see the racist element?
But citizenship is racist, and I think that it was reminded as like earlier, right?
Yeah, but in this judgment, it is defined through Article 2 values. So where does
I think in fact, for that I'm with Lior. I really think that the court used in fact solidarity to reinsert the genuine link, because the court clearly said like, and this is like basically why solidarity is there and why mutual trust is there, is because basically the transactional or the commodification basically is not enough as a link to become EU citizen.
But why not just say it's an equal respect and concern? So, I mean, there is nothing.
To me, and I think the it's not the yeah.
Some question. I mean. Obviously, I mean, a lot of EU member states are welfare states. I mean, is that actually a key consideration? I mean, if EU member states are not welfare states, would the decision be different, or would the consideration be different? Or like to the panel.
You mean that people then, so they might buy citizenship in Malta and then move to another EU state and receive welfare benefits there?
Something like that.
Yeah, they're too rich for that.
Yeah, they're too rich for that. Yeah,
it's more of an issue with the other groups, right? The people who get citizenship for free by ancestry, that it's much more likely that it would happen in those cases.
But he has a point. There is an interesting upcoming judgment on Danish housing.
Yeah,
and that is the question of how far the EU can interfere with hotspots in Copenhagen, and whether it can rely on the category of non-Western.
Yeah, and by the way, all of this is, I wrote a lot about this Danish case, and it's kind of interesting because this is not here linked to the rich, but to come back to the racial element of citizenship and Western non-Western, like this Danish case is about the gentrification of ghetto in Denmark, right? And only poor neighborhoods, which are mainly populated by non-Western residents, are being gentrified. And all of this is basically motivated based on the question of integration. So to come back to that question, which was asked, like citizenship, like racial discrimination, citizenship is about like race. I cannot agree more. And and I lost the track of my thoughts. Sorry. No, I forgot. So just it will come back probably.
Yeah, Ingrid.
But it strikes me as a sort of compromise. I mean, my personal problem with this judgment is the repercussion, is the avalanche, absolute avalanche of case law that we're going to get out of it, and the serious concern on immigration tribunals and modalities through the EU, which are already swamped at best, and now are going to be absolutely buried because everybody, on the name of solidarity, will start to question all the rules that you set. But on the other hand, maybe we're already moving to this. I mean, I say this as an Italian citizen. Guilty as charged. We had up to 3 months ago, anybody who had an ancestor alive in 1861 could claim Italian citizenship. And then the government, alarmed by the prospective potential 80 million who could claim it, although we have about 3 million that have already claimed it in the last 30 years.
But since 92, right?
Yeah. It's unbelievable. Has now changed it and has gone to only up to your grandparents will do. But on the other hand, we're having interesting discussions on the solidarity because the other clauses, in order to keep your citizenship, if you lack a grandparent, is you can come and have your child in Italy, and then that would allow them to keep citizenship. Or you can live for 2 years in Italy before your child is born, and then of course, under the Italian constitution, there are now problems with constitutionality because of the wealth aspect, because the argument is only the rich can afford to come and have private healthcare and deliver a child in Italy, and that will create discrimination between Italian citizens. So there are already perhaps convergence that is happening naturally, maybe also in reference to Europe, but maybe there are spontaneous through maybe national constitutional mechanisms that the path is narrowing. Maybe then we won't have all this avalanche of questioning, although on the other hand, on the jus sanguinis, I have to say it's a rule I believe in literally every single member state. I mean, they have varying rules on jus soli, but no one does not have jus sanguinis. So in a way, does it go back to our common traditions? That's also Article 2. So you go back to the
which is racist then, in a way. Yeah.
Yes, but I mean, I here have a general problem, which actually you touched upon. The welfare state had an implication. What we are discussing here is, it struck me in the panel, it's a very, on one hand, what I would call a globalist approach and the tendency in citizenship studies of looking at that line and in defining democracies and liberal rights. So liberal democracies versus social democracies and more communitarian elements. And it all depends on the optic that you take. I mean, it seems clear that in this kind of arguments, you're going for the globalist, internationalist argument. Sasha is a clear example of that. But obviously that is half of the picture. And you have the other half that you have to consider. And I would argue EU, and I think you have written, because I read your common article together on EU lawlessness.
EU lawlessness law.
Yeah, exactly.
And it's true there, Oliver, you'll have to read it, because there's Article 2 dogma. You will find we are not so good at keeping it externally. So, I mean, again, the EU is perhaps much more based on the communitarian aspect. An area of freedom, security, and justice is only for EU citizens.
Yeah, thank you so much for that. And I actually, thanks to you, I found the thought I wanted to say that actually you see a kind of a solidarity between member states, especially regarding migrants, especially at the borders, which is about exclusion of migrants, right? So if we come back to the question, like, what if we have like some kind of agreement, like at the supranational level of who would be a citizen? Like, indeed, there is this fear that basically like a lot of citizenship acquisition, which are much more generous today, will become much more basically restrictive because of this tendency at EU level. And we see it like at the border, how basically like member states are shielded by the EU regarding the 30,000 people who have died in the Mediterranean and are all Black. And so I think this is a reality that we really need to keep in mind when speaking about migration, citizenship, and solidarity, because there is this risk of slippery slope of having this solidarity regarding what's happening like to the non-EU, non-Western citizens. And this is, I think, a very dangerous kind of trend that we have here.
If we talk in these terms, and we must ask, where does the slippery slope come from? I mean, look at all the backlash in the member states themselves. Look at what Denmark is doing with regard to foreigners, to strangers. Look what is happening in Germany. They're all winning elections on the anti-immigrant platform. So it's not the fault of the EU as such.
Is it the fault of the immigrants?
No, it's obviously not. I mean, it is the member states which are frightened by and have no response to the problem of migration. And the EU can only do as much as it can do. But to say it is racist is just counterproductive, because the EU is what saves us from this racism. I mean, that's the argument you made yourself. So let's try to save what is good about the EU in order to deal with these backlashes in member states. Yeah, I mean, where I come from, in Germany, I mean, it's just outrageous to see that a country which has gone through fascism is 25% voting for these parties. Yeah, luckily there is the EU.
Can I bring this to Malta? In Malta, there is absolute bipartisan consensus about the need to sell citizenship to those guys who are now outlawed by the Court of Justice. So this attack on Maltese democracy under the pretext of some malfunctioning in Germany is very interesting, because it also makes Malta poorer by 2 billion euros that they have cashed in so far. I buy Madeleine's argument in terms of it was audacious, but it actually worked. It generated a lot of income. And then with the questions, I pick one in terms of how to combine teleology and going forward. This is one of the firsts, this case, because it's the first time when teleological argument has been used not to increase someone's rights, so not to protect someone from a weird member state far away, which that person will never visit, but in order to pointedly attack a group of Europeans, strip them of their status, strip them of their rights, and other them in the most absurd way by telling them that in fact their very existence as EU citizens is against our values. That's why it's a bullshit argument.
Shall we, on this note, continue the conversation next door over a glass of wine? Thank you very much.